I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are going through door number 189 on our compilation list. For this particular compilation, we will be in 3 different judges' courtrooms, 3 different states. Before I give you the rundown on those courtrooms, don't forget, commentary will be left in from when some of these previously aired here on the channel. Also, chapters will be added for your convenience. As always, it doesn't cost you nothing. I just ask that you like, comment, share, and subscribe to continue to help us out here on the channel. And now let me give you the rundown of the judges' courtrooms we will be in for 189. First, we will be in the courtroom of Judge Donald Allen out of the state of Michigan. And let me shout out Sovereign Citizen Chronicles for sharing this particular proceeding with me. Second, we will be in the courtroom of Judge Alex Manning out of the state of Georgia. And last but not least, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas. As always, guys, it is a pleasure to bring you guys these compilations, these proceedings, these videos. And listen, let's go ahead and jump into 189.
All right, this is case 260403. This is People versus Jessica Robles. Go ahead. Ms. Robles, how are you?
My special appearance
What does that mean?
on behalf of the named defendant, waive no rights.
Who are you?
I'm appearing by special appearance on behalf of the named defendant, Jessica Robles.
You're not Ms. Robles?
I'm on behalf of the named defendant.
So if you're not her, then I don't want to talk to you.
I reserve all rights, waive none.
Sure, talking. But if you're not Ms. Robles, you don't have any reason to be in front. It's Jessica Robles, that's who I'm looking for.
Yes, sir.
Looks like she is somebody that's not properly in front of the court, so you can return her back to locker until we have the correct person in front of me. Mr. Schuttenbauer, which case are you here on?
Robles, Jessica Robles. This is basically a status conference. We have our own criminal charges against her.
Does she have an attorney appointed to her?
Boy,
She took assistance of the public defender office at arraignment, Your Honor. I spoke with her before her PCC, and she also declined.
Come through one of the microphones. I'm not sure how well you're being picked up.
Just for the record, David Capelli, Assistant Public Defender. Ms. Robles declined assistance from the public defender's office at her arraignment based on our notes. I spoke with her on the day of her PCC about the extradition, and she again declined representation.
She doesn't have to have a lawyer.
Right.
So we could do that without her having it. But that was her that I was just talking to?
That was the person that I spoke to earlier, yes. I didn't do the arraignment, so I can't verify whether she was present for the arraignment, but the notes in our system did indicate a similar type introduction.
So she's one of those anti-government people?
That I can't speak to, Your Honor.
So that was Ms. Robles? You already sent her back?
I was gonna come back and make sure after the fact we do.
Well, now that I'm discussing this with the guys, it sounds like she's somebody that is an anti-government type of individual.
Yes, sir.
Yeah. So this was before the court on a status conference? Is that what it was?
Yes, as Mr. Schrotenbauer indicated, the prosecutor's office has their own felony charges on Ms. Robles. I think she was at that day at least represented by Stephen Milks from our office. I had an opportunity to talk to her about the extradition file prior to that hearing.
So it's a different jurisdiction is looking for her to be returned?
Yes, that's correct.
On Mr. Milk's file with her, is she cooperating with him?
I have not had a chance to talk with Mr. Milks about her cooperation on his file.
You have a number for him?
I can go look it up in our system.
Why don't you do that? And before you take her back, let's see if there's some sort of word game I'm supposed to be playing with her so that she'll cooperate.
I'll be right back, sir.
Okay, just to let the court know, she is scheduled for her preliminary examination in Your Honor's court 1 week from today.
So I had the privilege of conducting her pre-exam conference as well.
I don't think this is a pre-exam conference.
I'm talking about next week.
Oh, next week. I thought it was the preliminary. Yeah, the preliminary examination itself. Yes, next week.
Okay.
That is the one where Mrs. L said the witness had mobility issues, so you didn't speak with her. So
Okay.
they wanted time to actually bring the witness in because they.
So that could potentially end up being dismissed if the witness doesn't show up.
It could be. But I know Mrs. L was trying to get her.
I'll probably put it on her thing. Sorry, no, telling jokes. Probably the thing for us to do is to just adjourn today's proceeding until Tuesday next week and see if she's in a better mood to talk to us at that point.
Well,
Okay.
I'd be asking for an adjournment anyway, so I have no problem with that.
So this matter is adjourned until next Tuesday. Is that going to give you enough time, Mr. Schroeder?
Well, yes, yeah, easily.
Okay. So that's what we'll do. We'll just adjourn this until next week on Tuesday. And did she say why she didn't want you to represent her, but she wants Mr. Milks to represent her?
It was unclear. I didn't have a lot of opportunity to speak with Mr. Milks as he was kind of running around like crazy that morning. My conversation with him seemed to indicate that she was comfortable with him, but didn't want any representation on the extradition.
Why don't we do this? Let's see if we can have him represent her on both matters.
Okay, he's certainly capable. I will give him a call and see. Ultimately, though, it would be up to Ms. Robles.
Yeah, it would be. All right. So let's just adjourn this for consideration of having an opportunity to speak with Mr. Milks and to see if she'll let him perform his duties for her. Let's do that. Okay. So this will be adjourned until next Tuesday. That date would be, today's the 7th, so that'd be the 14th.
Yes.
So that would be scheduled at 9:30 though, okay?
Okay, that's fine.
All right, then that's going to be all for that matter. You can take her back.
Kapuma.
No, your last name.
I am Kapuma.
Okay, what's your last name? Wimbishi?
Kapuma is my last name.
Okay, so what's the first one then?
Mwembeshi.
Okay, there you go. They have it reversed. Thank you. Okay.
Yes.
Yeah, okay.
Oh, they
So-
have it reversed? Okay.
So it's Wimbishi Kampuma.
So your name was, like, your last name is Kapuma then?
My last name is Kapuma.
Okay, we'll make sure didn't want to destroy it, too bad with my accent. So I guess they need to know that because they have it reversed.
Yes, and because of that, it's an invalid contract.
Well,
Because
not necessarily, that's just a typo, but.
yeah, but according to this,
We're just kind of getting started here, okay? So I'm just trying to pronounce your name right. That's basically all that is, okay? All right, so this is number 122 CP 214772. Here it's Kapuma Wimbishi, but it's actually Wimbishi Kapuma. So I think they could probably modify that at the jail. I guess y'all want to take care of that. Okay, so we got 285 days without indictment. He had a Ferretta hearing and he's representing himself. So it's aggravated battery, willful obstruction of a law enforcement officer with a felony. Officer, if you could raise your right hand for me. Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, ma'am.
All right. If you state and spell your name into the microphone for the court reporter, please.
Yes, ma'am. My name is Patrick Marsh. First name is spelled Patrick. Last name is spelled Marsh, Marsch.
Okay, Officer Marsh.
Okay, so 1 second. So, sir, what this is a preliminary hearing, okay? It's just to establish that there's probable cause. So the DA is going to ask some questions and then you get to ask follow-up questions, okay? All right. So go ahead, Ms. Fields. And this is Ms. Kelly Fields. She's one of the assistant district attorneys. Go ahead, Ms. Fields.
Thank you, Judge. Officer Marsh, can you tell us, you already told us your name, but can you tell us where you work and what your title is?
Sure. I work for the City of Atlanta Police Department and my title is rank as an officer.
Okay, and are you post-certified?
Yes, ma'am, I am.
Were you post-certified on the date in question? On December the 15th of last year?
Yes, ma'am, I was.
And can you tell us what happened on that day?
Sure.
Regarding Mr. Kapoor.
Sure. So on that day, I was dispatched to a call at 1776 Peachtree Street. There was a fight going on that apparently was going on the fourth floor at the clubhouse. We had received several calls as well, arriving on scene from a passerby saying that there might be a weapon involved. So I immediately called for backup. Officer Jones and Officer Easton arrived on scene to assist me. We go up to the fourth floor. We go to the right where the clubhouse was, and we found a white male victim named Johnson that had a gash to his forehead. We had asked him what had happened, and he said that he had been knocked out by the defendant.
When you say knocked out, can you tell us what that means?
Sure. So apparently the defendant said that they had noticed, the victim had noticed the defendant acting in a strange manner. And when he went to put his hand on his shoulder to ask if everything was okay, he advised that the defendant hit his upper right eye with a closed fist, causing him to go to the floor and was unconscious.
Okay.
During that time.
So he was unconscious?
He was unconscious, but he was not unconscious when we arrived on scene. But
You were gaining consciousness?
Yes, ma'am.
Okay, now you said that this happened at what address?
Peachtree Street.
Is that in Fulton County?
Yes, ma'am, it is.
And can you identify the defendant and describe what he's wearing and where he is in relation to you?
You can stand if you need to.
Oh, I can see it on the screen here, ma'am.
Yeah, that's okay.
Thank you very much. Yes, I can see the defendant. He is wearing a blue Fulton County uniform with a white shirt under it.
Okay. Let the record reflect that the witness has correctly identified the defendant.
All right, noted.
So we talked about that Mr. Kapuma rendered this man, Mr. unconscious. And is that the basis of the aggravated battery?
Yes, ma'am. So under the code section of 16524, the elements of the crime for aggravated battery indicate that you render a limb unconscious. And so with the brain being a member of the body, we decided to go ahead and move forward with the aggravated battery because the brain was rendered useless during that time.
During the time that you was unconscious?
Yes, ma'am.
Okay, and did EMS arrive?
I'm sorry?
Did EMS arrive?
Yes, ma'am. Mhm.
And what happened with that?
I'm sorry?
What happened with, excuse me, I'm talking
Okay,
about-
all right.
What happened with that?
So during the incident while we were trying to get the defendant into custody, he was resisting myself and numerous officers. So one of the officers on scene had to deploy a City of Atlanta issued taser in order to try and get him into custody. And during that time, that's why we called EMS to go ahead and have them remove the prongs as well as go ahead and check his vitals because he did appear to be acting in some type of irregulated manner, whether it could be on, just having a mental breakdown or something of some nature, but he clearly needed some medical attention, which is why we go ahead and called EMS as well.
Was EMS called for Mr.?
Yes.
Okay, did he allow them to treat him?
He did not need EMS. When we got there, we asked him, he said that he did not need it. Some of the witnesses and the friends who were at the event were tending to the victim.
Now, with the charge of willful obstruction, was there any violence or offering of violence or just resistance?
There was no offering of violence. There was just actively resisting when giving verbal commands.
Okay. And you said that Mr. Johnson was concerned about how Mr. Kapuma was acting.
Yes. So
can you describe how he was acting and what you were told?
Yes. So what I was told by the victim is that at some point this was a company event that was going on, and during the course of the event, at some point, the defendant had according to Mr. Johnson, had put his AirPods into his ears, and he started being very incoherent, saying a whole bunch of stuff that Mr. Johnson did understand, and according to him and several other people at this event, they had never seen the defendant act in this manner before. And so when Mr. Johnson went to put his hand on the defendant's shoulder, that's when the defendant acted out.
Altercation happened.
Yes, ma'am.
Okay. Do you have any other statements you'd like to make to the court regarding these two charges pertinent to this case?
That's pertinent to this case, no.
Okay. That's all I have for right now. It's your witness, Mr. Kapuma.
All right, Mr. Kapuma.
Okay, thank you, Your Honor. I have a question, right? Because according to this warrant, first of all, it shows here that he was called for a fight.
Okay, step back. What questions do you have for the officer?
Yes, that's who I'm asking, because I can't see him, so.
Oh, okay.
You can't see him on your.
Okay, so he was called in for a fight, right? So according to this statement, Keith Johnson put his hand first on me. Then I reacted to that with a punch. It doesn't show how hard he pushed my shoulder. It was in a hostile situation because I was at a party.
Okay, so stand by, Mr. Kapuma. What is your question?
So
Who, what, where, why, when?
so in that situation, who was the aggressor in that situation? Because he put his hands first on me.
Just ask a question.
So, okay, so based on when we spoke to the witness, I had the witness actually show me how he placed his hand on the defendant. And Mr. Johnson said he basically just placed his hand in a almost caring way, just a concerning way on his shoulder to see if everything was okay. And that's when the defendant acted out and hit the victim.
So is there a written signed statement from the witness about that incident to describe what you're saying so that they sworn like a sworn affidavit?
Who, what, where, why,
I'm
when?
gonna have to object. Compound question. Can we?
All right. So you ask a question like this. Do you have a written statement from the victim?
Do I have written a statement? No. Do I have it on body camera? Yes.
Okay. Next question.
So there's body camera for the entire event from all 5 officers of what happened?
Yes. So my body camera was activated from the time I arrived into the parking deck before I made contact with anybody up until the very end of the incident as well. So there is a full body camera footage from start to finish, including a body camera footage from each of the officers during the interaction as well.
Okay, so from my recollection, right?
Whoa. No. If you want to say something, you have to ask him a question. So she asked him questions, so you ask follow-up questions to what she asked.
Okay. So based on the body cam video that you're saying, does it show that I was tased until I passed out or died and then had to be resuscitated?
So the body camera footage from Mr. Jones, I would appear because Mr. Jones is the one who tased the defendant, but the defendant at no point in time lost any consciousness or at any point in time had to be resuscitated by Grady.
Okay. Next question.
So I understand. So when will I be able to see the body cam? Because I haven't had a chance to look at it, see what exactly happened on that event.
All of that gets turned over at discovery, but allegedly you were there. So what's your next question for him?
According to the law, which I'm new to, did I give consent to be arrested? Because according to the
Judge, counsel, or I don't know if I should call him counsel, but
that's actually,
he's been testifying, and so we object to testifying.
so did you give consent to be arrested? Did he give you his consent to be arrested?
Your Honor, he did not consent to get arrested, but based on the elements of the crime, we had enough probable cause to make the arrest.
Next question.
was based on my understanding.
No. Next question. If you want to say something later, you can, but what's your next question for him?
Okay, so in terms of the resisting arrest, is it not my right not to resist if there's no jurisdiction over me?
You said stand up.
No, I told him to stand by. I didn't know if you had an objection.
Yes, I have a judge, I understand when you're giving him leeway and I understand the reason for that. However, counsel has been not asking direct questions on cross and he has been testifying numerous times. So we just have an overall objection to that testifying that's been happening from pretty much from the start of this questioning. So we ask that he ask direct questions, you know, not have this kind of commentary in addition to his questions.
So what you're asking is him to draw a legal conclusion. So
Yes.
what's your next question? What's your next question for him?
Because for me, it's mainly about consent and jurisdiction.
Okay, hold on.
Mhm.
But that's argument. But what question do you have for him?
I don't have any questions for him.
All right.
Okay.
Anything else with the officer?
I do have some redirect.
Okay, go ahead.
So, officer, I know I was calling this. That was my mistake. I meant to say the correct, but and the correct victim's name is Johnson. Is that correct?
Yes, ma'am.
And Mr. Johnson was hit by Mr. Kapuma.
Yes, ma'am.
Okay, and that's all I have.
Thank you, ma'am.
All right. Any follow-up based on those questions that she asked?
Basically, not really.
Okay. Thank you,
Okay.
officer. Stay safe
Thank
out
you.
there.
Thank you very much, Your Honor.
Have
You
a
stay
good
safe as
day.
well.
All right. Go ahead with the argument. What's here from the state?
So, Judge, I believe that we have met our burdens for our probable cause for the first charge, which is aggravated battery. The defendant did render Mr. Johnson's brain useless by, you know, rendering him unconscious for a period of time, where he did, you know, fortunately regain consciousness, but he was rendered unconscious for a little while after he was struck by Mr. Kapuma. And as far as the willful obstruction, we understand there was no violence or offering of violence against, you know, the officers and you know, Mr. Marsh and other officers at the party. So we suggest that that should be a misdemeanor and not a felony. But other than that, we think there's probable cause for both charges, as just stated by myself and the state.
All right. Do you want to respond? Now, this is where you give argument. So now is your chance to give argument.
Okay, so first of all, based on just this warrant, my name is spelled in capital letters. It's in reverse. From my understanding of law, that's a name of a strawman or a corporation. So that does not apply to me. It says the accused is capitalized. That's a corporation, and the strawman, which has no bearing to me. And in this matter, I do not give consent or agree to represent my strawman in this case, because I'm a sovereign being. I'm an internationally protected person. But at the same time, from my understanding of the constitutional law, which is the law of the land, I have to give informed consent or sign a contract in order to be judged or in order for the case to move forward in this regard. Because according to the Fifth Amendment, one of the things is before I can be arrested or detained, I have to be indicted. I have not been indicted. One, I did not give consent to be arrested or to be tried under this jurisdiction, because I operate under common law. That's my jurisdiction: common law, God's law, and natural law. I do not consent to be tried by the Admiralty law system, which is evident by the God fringe on the flag and the eagle at the top, which shows this is the maritime law, which is commercial law. And as a sovereign being, I report to God. God is my judge. As it relates to how I interact with other humans, it's only by common law, which is when I injure a human being, and that's also dealt with in the common law court. And based on my international status, because I am a king where I come from, an internationally protected person. So according to Executive Order 143107, which is human rights, this is a violation of human rights. From my understanding of the law and my rights, my unalienable rights, if I have not given consent to be tried or to be held or to be detained by or given jurisdiction authority to the officer, and they arrest me, that's a kidnapping, and I'm being held hostage right now. Because according to the Constitution, I have to be indicted before I can be detained. That's according to the Fifth Amendment rights. And the Constitution, from what I understand, is still the law of the land. Because according to the Supremacy Clause, every case, if I can cite one case, which is the Madison versus Marbury, every case in that situation, which cited that case as into the legality of the Constitution or unconstitutionality of any situation, was overturned by the Supreme Court. So in this situation, yes, I did react to Johnson putting his hands on me. Though the witness may have said something, they might have been friends with Johnson. I reacted to a situation. For every action, there's an opposite and equal reaction. He touched me first. I reacted. When the officers came to arrest me, I didn't do anything wrong but defend myself. I've been charged with willful obstruction. According to the Constitution, according to my unalienable rights, according to my human rights, I've got the right to defend myself. If I put up on anyone over here and just touched you on your shoulder without even asking for your consent, some people will tase me. The officer will shoot me. But if the same thing happens to me, he touched me first. I reacted off of that. That's self-defense.
Okay, anything else? All right, so I'll find probable cause on the aggravated battery, and then the misdemeanor, the willful obstruction will be reduced to a misdemeanor. And we'll go ahead and address bond. Let's see, because right now, bond, let's see. Right now, as of June 27th, there is a $30,000 good bond.
The defendant has 3 cycles. The defendant's last arrest was May the 9th, 2021 in Dunwoody, Georgia, for Terroristic Threats Act and possession of a firearm during commission of a felony and criminal attempt to commit a felony. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
All right. Go ahead with your bond argument, sir.
First of all, it was just a punch, and I don't see how it can be a felony. And if it was pretty much a misdemeanor at best, because one, it was self-defense, misdemeanor at best, the maximum is 1 year, and I've already done 10 months in jail pretty much for one punch in self-defense, in defense of myself. At the same time, I feel like I have already done the time for this.
Okay, anything else? All right, what says the state?
Judge, the state is inclined to keep the bond as is because the severity of the injury that took place. Yes, Mr. Johnson, he was rendered unconscious. The punch that, counsel is trying to minimize was very severe. The punch took him out. So because of that, and then him resisting arrest, we do believe that a $30,000 bond is sufficient.
All right, so it'll be no further contact with Johnson. Stay away from Peachtree Street Northeast. You're going to have no drugs unless prescribed, no alcohol, no weapons. It's going off my bond order of 627. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Are you still going to live in Roswell, sir?
Sandy Springs.
Sandy Springs, okay. All right. So just supply a good address to the jail upon release. So 15,000 count 1 and count 2 is reduced to a misdemeanor, so that'll be 5,000. So $20,000 good bond. Best of luck to you, sir.
Well, guys, we've come to the end of both of these proceedings. Wasn't a whole lot to say about the bond hearing. $30,000 bond. His preliminary hearing hits. He's been in jail 10 months. As soon as it starts, finds out that his name has been spelled backwards or put it on the paperwork backwards, tries to use that as a tactic to get his case dismissed. Wasn't happening. He talked about the straw man, being a corporation, all of these different things did not help him. And we see that this is a serious case where he knocked the man out. Mr. Johnson rendered him unconscious, as we heard from the police officer's testimony. and he said that he got, the details from some of the witnesses that were there. But one thing I will say that Mr. Kapuma said that I do agree with, who's to say that these witnesses that the cop got testimonies from wasn't some of Mr. Johnson's friends, and who's to say that that grab on the shoulder wasn't aggressive? Maybe it was, or maybe it wasn't. But we hear that, Mr. Kapuma was definitely acting erratic and a little crazy to the point of where they had, medical attention come and look after him and not even Mr. Johnson. So definitely sounds like something was going on with him. We see how he's talking in this hearing. He's talking about he's a king, where he's from. Just all of these different things that he was saying definitely shows that something's going on with him. But he did get a little bit lower bond than he had at his bond hearing, so maybe that helps him out. This case, I did a tiny bit of digging to look for his next appearance. Judge Manning does, keep her videos available, because a lot of judges, sometimes they don't, but I'm gonna have to do a little bit more digging. I wasn't able to do like a heavy digging, but even the little digging that I did, I wasn't able to find anything yet, but I will keep you guys updated on it. I thought this was interesting when it came to my attention. So hopefully we can find the rest of it. And if I do, you guys know what I'm going to do. I'm going to stick them all together. So that way, it just be an easier viewing process for you all. But with that being said, this is Sovereign Citizens Hall of Fame. As always, guys, I appreciate you. Don't forget to like, share, subscribe. With that being said, this is Sovereign Citizens Court. And for now, guys, Sovereign Citizens Court is adjourned. Thank you guys as always, and God bless.
We are on the record in the 13th Judicial District Court of Greenwood County, Kansas. This matter comes on for review in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Paul E. Dean appearing for the state, Mr. Abel Estrada Jr. appearing in person and pro se via Zoom. Now, Mr. Estrada, you were convicted of displaying an illegal license plate. You apparently had a legal plate in your car, but you chose to put on your car a plate that you had ordered specially made from a company, and I can't remember at this point what it said. You didn't like the decision, and
Your Honor, this
there
was
it
the
is.
exhibit.
There it is. Thank you. And that was manufactured at your request by a private vendor, and you were found guilty, and you said you were going to appeal. I don't believe you have paid. I don't believe you've posted your appeal bond. Then you filed some motions for today, but the main concern is you need to either pay or appeal, perfect the appeal. And if you don't, I'm going to have to direct the clerk to send in the notice to the state to suspend your license for non-payment. So let's take a look at the file. Okay, I do see something dated 2/19/2025. Appeal, notice of appeal to appellate court, and you filed that notice of appeal. So you started the appeal process, but typically they don't accept those until or unless accompanied by an appeal bond. And you did not pay that cash bond, did you?
No, I didn't. I actually did the papers, and I got a letter from the appellate court, and they said that I needed to be signed. I sent it in, but it needed to be signed, so I submitted. As soon as I got it, I submitted it to your office, and then they told me at your office that you wanted to see me today here about that letter. All I need is to get a signature. I perfected all the paperwork. For some reason, it didn't go. But if I get the signature, then I'm continuing. I'm doing it. Everything is supposed to.
Well, I see you filed one page. It says motion to proceed in form of papyrus. I, Abel Estrada Jr., is disabled and am requesting for a waiver of court fees for the appellate court. Sincerely, Abel Estrada Jr., and it's signed and dated 2/28/25. Well, apparently, Mr. Dean, that's up to the district court to make that determination on an appeal. I would have thought the appellate court would have made that.
That would be my understanding as well. I don't know what letter Mr. Estrada is speaking of. We don't have anything. I don't have anything that shows. I've got the notice of appeal. Mr. Estrada has not been sending copies as would be required to opposing counsel of his filings with the Court of Appeals. We've received nothing. Mr. Estrada, in criminal cases, civil cases, whatever kind of case you're involved in, when you have another side to the case, which is always the case, if you file something, you're supposed to be providing copies to the other side so we know what you're doing. Just as we file a notice or something of that nature, we have to send you a copy. If we file a motion or something else, or they did the initial complaint, you get a copy of it. Etc. So I don't know what he's speaking about. I just know that we've had judgment for some time on this case, and let me see.
If I may.
Well, I show the journal entry of trial. Let me see if it was filed February 21st, and that shows that he was found guilty of displaying unlawful tag.
I think he's still within his 60-day docketing time period. So
I think so too. So, Mr. Estrada, what is it you want to say?
Here's the letter that the appellate court sent me saying that I just needed the this one. I just needed the signature on the papyrus, formal papyrus. I don't know if you can see it.
no, we can't. Why don't you read it to us, Mr. Estrada?
Oh, I don't have my glasses. Well, can you read it for me? I have my glasses because I don't have my glasses. Yeah.
Mr. Estrada, the office received on April 2, 25, your certified envelope postmark.
Ma'am, hold on a second. Sorry, could you come more in front of the screen because we're getting a really I'm at least getting a muffled sound. I can't really tell you.
I can't track it. If you get in front of the camera and tell us your name.
Hi, my name is Annie Estrada.
Anna Estrada?
Annie Estrada.
Annie, A-N-N-I-E?
Yes.
Anna Estrada, and you're the wife of Mr. Abel Estrada Jr.?
Yes.
And you have a document in front of you with the Court of Appeals? Okay. If you'll slowly and loudly articulate that, because it is very muffled for some reason.
Did you want me to read the whole document?
Well, just the
pertinent part.
Okay.
Body of the letter.
Okay.
Where it says, I'm assuming dear Mr. Abel, and then whatever's below that, or dear Mr. Estrada, excuse me.
Yes, the office received, Mr. Estrada, the office received on April 2, 2025, your certified envelope postmarked March 31st, 2025. You enclose the documents which we have reviewed. At this time, you're unable to docket an appeal based upon the following issue. First, we need either the docketing fee of $155 or a file stamp copy of the signed order of indigence by the district court judge. You have enclosed a motion to proceed in form of papyrus, but no order by the court has been provided. Next, we need either a file stamp copy request for transcript document filed with the district court with service on both the court reporters and opposing counsel, or a statement that no transcripts will be requested with service on the opposing counsel. A request for transcripts must note that it is being made for purposes of an appeal and must comply with rules 2.04 and 3.03. Finally, please be advised that docketing must occur within 60 calendar days of the filing of the notice of appeal with the district court. If this does not happen, then it will also be necessary for you to submit a motion to docket appeal out of time to this office, along with the items noted above. This motion must also be served by you opposing counsel.
Yes.
It appears your deadline for timely docketing would be April 21, 2025. As a result, a motion to docket out of time is not currently required, and we cannot hold the motion you have submitted as it does not serve your opposing party. Only the appellate courts of Kansas. The remaining documents you have submitted will be held by your office on your behalf for a period of 6 months pending receipt of the items noted above. This office is unable to provide legal advice or assistance.
All right, so you have not perfected your appeal. You've merely filed a notice of intent to appeal. Sounds like that's the only thing you have, and that the Court of Appeals is not officially recognized.
Your Honor, it also sounds like the Court of Appeals gave him a checklist of things he needs to accomplish that we're not authorized to advise him how to complete.
Right.
Which I already did.
Clearly you haven't, sir, because the Court of Appeals just told you the list of things they need you to do, including sending a copy and certifying that you provided me a copy of things that you filed with the Court of Appeals. They specifically...
Don't interrupt him. Let him finish.
They specifically advised you that you had not. And I have not received anything from you except for this motion to dismiss liability, which, Your Honor, I don't know that I have anything to argue on that other than it's nonsense, and I'd ask you to deny it. I mean, it does it. I don't even know what he's attempting to do, whether he's asking the court to reconsider the judgment, doesn't state that, whether he's asking the court to make an indigency finding. He has presented, other than naked statements that he claims he is, has provided nothing to the court to make that consideration, or whether he's asking the court to waive the appeal bond. It doesn't say that either, but those are the three logical conclusions I could come to that he's trying to request. But I don't believe anything's been presented that would give him relief, and that's all I have to say on the topic.
On your motion to dismiss liability, let's take that up. It says, I reserved my right not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly nor voluntarily or intentionally. Furthermore, I do not accept any liability of a compelled benefit of any unrevealed contract of a commercial agreement. And then it's signed Abel Estrada Jr., living man, authorized representative for Abel Estrada, straw man. Now, I'm going to deny that because I share the state's comment or belief that it makes no sense. It doesn't have any legal argument in it. So motion to dismiss liability, whatever in the world that's intended to be, is hereby denied. The journal entry of continuance, did you file that?
I think the journal entry of continuance, Your Honor, may be the last one where we were reviewing the status of the appeal and or the payment of costs and fines.
That's what that was. Okay.
And the payment of the appeal bond. So I believe that was a late April date on the perfecting the appeal. So I would ask the court to set this over to someday in early May. It hasn't been properly completed at that point in time. The state would be moving to dismiss the appeal.
If I may, I did submit copies of everything that they asked me to your office. And by the way, the actual April letter that I sent certified, that was the second letter that I sent. I sent it because when we went to court the last time, it didn't seem like you guys got anything, so I resent all the paperwork again for the second time. But all they're asking right now is the papyrus indigents, which you already have, and then the request for the records. I already sent it in, and I sent the COA. So I did the paperwork. It's been sent, and you guys, everybody got a copy of it, or at least at the court of record. That's what they told me. They said, do I need to send one directly myself, or do you get a copy? I'm talking Mr. Dean, the judge and Mr. Dean gets a copy, and they say, no, don't worry, they get a copy. So I submitted that to you guys already.
Okay, when you say I submitted to you guys, who do you mean?
I'm sorry?
Who do you mean when you say I submitted it to you guys?
To the court of record,
Who is the court of record? Is that the district court? Is that the
district court.
Court of Appeals? Did you send it to the clerk? You sent it to the judge?
I send it to you directly, magistrate, and I send it, I put it on the court of record. So they told me there at the court of record that you're gonna get a copy also. That's why I submitted this already.
I see where I signed off on an order to remove a document from the record that you had apparently misfiled, a motion to docket appeal out of time. And it was premature. You shouldn't have filed that. So that was removed. Missy, didn't you show me that he had brought something into the office, but I'm not seeing it in the file. I don't know what he brought in. Do you have that, or should I have that somewhere? It seems like I saw something that he may have. Missy, are you there?
Yes, I'm here, Judge. I can see there was a paper. Let me go see what it was.
See if it's the clerk's office. But as far as the informa pauperis, I have not made that determination. I did appoint you, perhaps I shouldn't have an attorney, since this isn't or wasn't the level of a jail sentence that would have entitled you to the right of an attorney. And you fired that attorney, and then we appointed another one, and you didn't want to use him. But as I recall, you do have a monthly income. And remind me, does your wife work?
No.
Okay, well, I have never seen, I've never made that determination, and I'm not inclined to make it at this time. You do get some income, as I recall, and if you can afford the transcript to be made in this case, I don't know why you couldn't afford to pay the filing fee.
I'm requesting the papers because it'll cover it. And then they told me at the court this morning that when I do the request, that it's not gonna be charged to me. I don't have to pay for the request. And all I need is the letter that I submitted, which is, for some reason, they're asking for you to sign. So I submitted it to you as soon as I got it.
Your Honor, I would respectfully request the court to, the court's denied the motion that was before the court today. Set this matter over to early May. Mr. Estrada wants to argue things, in my opinion, to this court that's claiming conclusory issues that it's been completed, yet the letter that was just read to us specifically contradicted numerous things that he said that he's done and taken care of. I just sent a message to my office to confirm that we've received his copy of the of this motion to dismiss liability. I'll give you one piece of advice. When you're filing something, what the court said is you need to send notice to me. You put a certification here at the bottom saying, listing everybody, whether it's Greenwood County Attorney, the District Magistrate Judge Webster, and their addresses, and the date you mailed it. That goes here. That's called a certification that you provided notice to the other side so the other side can properly respond. Nothing. I don't even know that you actually know her address in any event. I think Mr. Estrada has a number of issues that he's been specifically told in that letter that needs to be addressed, and he needs to address them in the fashion that he deems appropriate. And we should review it in May.
All right, Missy, what do we have in May?
We have May 9th. I think that's the only May date we have.
Okay, what time? 11?
11.
All right, I'm going to continue any remaining matters. Well, I'm going to continue the pay or appear to May 11 at 9 a.m. You're either going to have that paid and cover all of those matters that the appellate court has listed, including paying that appeal bond, also known as a supersedious bond. That needs to be paid of $158 cash.
May I ask a question?
Go ahead.
Yeah, I just need to know if you're going to sign the formal papyrus letter that I sent you.
I'm not signing that at this time.
Well, guys, we've come to the end of this proceeding. And just like I told you guys, Mr. Estrada definitely still has his sovereign citizen head on. And a matter of fact, if you guys haven't seen any of his appearances, his trial, appeal, any of those, we will have links in the description down to those so you can check those out. But yeah, he's still going hard with some of the same lingo. He hasn't paid the appeal bond, which, you know, they keep telling them, listen, you're going to have to pay that appeal bond if you really truly want to appeal this. But, you know, in previous appearances, he said he doesn't have the money. So it's like he's trying to figure out a way to have, you know, that taken care of for him, whether it's through the taxpayers or whether it's through the court waiving it. But, you know, he hasn't provided the prosecutor documents that he's supposed to provide him. You know, the appellate court says he also has a checklist of things that he needs to get done that he hasn't done. And as we can see with prosecutor Paul Dean, if you follow this case, man, he's not too fond of Mr. Estrada. Every chance he gets, man, he takes a shot at him. But I don't know. We see this is just another continuance. I don't know if this guy will be back or not. I mean, at this point, I never like to tell anybody to give up on anything. But at this point, you know, I think they're going to, you know, eventually just deny his appeal, and he's going to end up getting that license suspended for not paying the stuff that he was supposed to pay. And with that being said, before we close out, I must say, Judge Webster, she looks a little different. Her face seems a little smaller. So I don't know if she lost a little bit of weight or what, but her face looks really skinny. She looks a little different, even though, you know, we know her motions of fixing her glasses. I mean, obviously we know it's her, but she definitely looks a little different. So, you know, maybe she ended up losing some weight, has some stuff going on, but good for her. But with that being said, this is Sovereign Citizens Hall of Fame, guys. As always, I appreciate you guys joining me. Don't forget to like, share, and subscribe to the channel. Thank you for all of you guys that's been supporting the channel through Buy Me a Coffee. That has truly been a blessing. And I appreciate any other, donations or sponsorship or whatever else is going to come through that. I want to thank you guys in advance. But with that being said, guys, this is Sovereign Citizens Court. And for now, guys, Sovereign Citizens Court is adjourned. I'll catch you guys on the next proceeding. God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.